Have you ever heard the phrase, making the rubble bounce? Well, I think it's fair to say that the United States Supreme Court in NYSERDA versus Bruin just made the rubble bounce on those lower courts that hate guns and upheld all sorts of crazy gun control legislation. I'll tell you about it in a second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, even a best-selling author. For those of you new to this channel, please subscribe to the Four Boxes Diner, and please share these videos. We're working hard to get these videos distributed to other people. We'd appreciate it if you could help out in that regard. Okay, folks, I gotta say, the more I read this Supreme Court decision by Clarence Thomas in the NYSERDA versus Bruin case, the happier I am. And we're going to keep talking about these inside details that I've been able to flag, and I'm going to bring them to you because it's going to save you the trouble of having to read 100 plus pages of single-space type and try to understand what all that verbiage means. But I want to talk about something specifically. In one of the footnotes in NYSERDA versus Bruin, the Supreme Court basically took all the major anti-gun decisions by federal courts and blew them up, blew them to smithereens. And I'm going to give you the list of the cases and the types of gun control legislation that the Supreme Court just blew up and said that the lower court cases that upheld these gun control laws did it all wrong and they have to be redone in one form or another. Or at least they can be re-challenged, and those precedents are no longer binding and helpful to the anti-gunners because the Supreme Court says they didn't follow the Second Amendment, they ignored the text of the Second Amendment, and they didn't apply the correct standard. Let me just give you this list here. I think this list alone is impressive enough. And for those lawyers out there, or you classics majors, res ipsa loquitur when I give you this list. The thing speaks for itself. When I give you the list of the types of gun laws, the Supreme Court says the lower courts were wrong in upholding under the old standard. We'll see what happens under the new standard that Bruin talks about the text and history test. But under the old standard of tiers of scrutiny, intermediate scrutiny, balancing test, the Supreme Court says these cases were wrongly decided. I'm going to give you the list. And again, I think the list speaks for itself as to just how powerful the Supreme Court decision is in favor of gun rights. And I'm sure how many liberal tears, if I can talk about what other people have said on other channels, how many liberal tears have been spilled over this decision of NYSERDA versus Bruin. To begin with, the first case they said was not properly decided was Association New Jersey Rifle and Pistol Clubs versus the Attorney General of New Jersey in 2018. That involved upholding a ban on so-called large capacity magazines of 10 rounds or more. Then the Supreme Court said in the case of Warman versus Healy, which was a First Circuit case out of Boston from 2019, that decision that upheld Massachusetts' so-called assault weapon ban was wrongly decided as well. No good. Then the Libertarian Party versus Cuomo, Libertarian Party of Erie County versus Cuomo in New York says that the standard for good moral character and good cause in order to be able to buy a gun, to possess a firearm in your home, the Supreme Court just says that case applied the wrong standard, wrongly decided. And then there's the NRA case versus the BATF, that's the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Don't forget the explosives now. This was a case involving whether or not it was lawful under federal law to deny 18, 19, and 20-year-old young adults the ability to be able to buy handguns from FFLs, or federal firearms dealers. And again, the Supreme Court just said that case was wrongly decided because they applied the wrong standard. Then, and I think this is the most important case to some degree, especially for those of you out there that talk about felons in possession, we're going to talk about that in more detail. I do have very specific thoughts on that, but I want to share that in a full-blown video. Cantor versus Barr. Cantor versus Barr. Now, you've heard of this case before. Why? Because this was the decision that then Judge Amy Coney Barrett wrote a dissent in, and the question presented in Cantor versus Barr was whether or not non-violent felons, people like Martha Stewart, convicted of mail fraud, convicted of securities fraud, this kind of white collar stuff, no violence associated with, but it's technically a felony, whether or not those laws that banned non-violent felons from being able to possess firearms for the rest of their lives, whether that was constitutional or not. That was Cantor versus Barr out of the Seventh Circuit. And guess what? The Supreme Court just said in Bruin that that case, again, was wrongly decided because they applied the wrong standard, and therefore it's not proper precedent to be relied on in the future because it wasn't done right. And that's important because, again, the dissenter in that case was Amy Coney Barrett, who was one in the majority supporting the Second Amendment right to bear arms in Nyserpa versus Bruin. Then, of course, we have the United States versus Reese. This was actually a 10th Circuit case, I believe, out of Colorado, where he sought to dismiss an indictment where he was charged with possessing firearms, even though because he was subject to a domestic TRO, he was subject to a domestic restraining order at the time he possessed firearms. He was indicted, and the Supreme Court said that that decision, the standard they applied, the standard review they applied in that case, no good. No good. They applied that two-part test. The Supreme Court says no good. They didn't do text and history and stop. Therefore, that decision is not binding precedent. It's not real law anymore as I see it. Then you have the case, two sensitive places cases. As you know, sensitive places are euphemisms for gun-free zones. We had a case in 2012 out of the 11th Circuit. That's Atlanta, Georgia, also includes Florida. In this case, it was Georgia. The case was Georgia Carry Org versus the state of Georgia. In that case, the state of Georgia declared that, among other things, churches were sensitive places, and therefore they could ban guns no matter what happened down there. There was a legal challenge brought, and again, the 11th Circuit applied the wrong standard, and the U.S. Supreme Court just last week in Nyserpa versus Bruin said, guess what? That decision, again, is on the list of things that was improperly decided because they applied the wrong standard. They applied those tiers of scrutinies that you and I have talked about for many, many months, and why those tiers of scrutinies are balancing tests that balance the rights of you and I against the powers of the government and the interests of the government, and no can do. That is not how you apply the Constitution or the Second Amendment, and that's exactly what the Supreme Court said, and that was the right choice. But you and I, we've been talking about that for many months before the Supreme Court did this. So if you've been following this channel for all these months, you were ahead of the game, and you knew what the Supreme Court was going to do before they did it. That's why I try to make you guys the smartest people in the rooms when it comes to the Second Amendment, no matter what room you're in. And last but not least, there was a case called United States versus Class. This was the District of Columbia, 2019. It was a terrible case. This guy was arrested for having 3 firearms in his car. He admitted to it. He had firearms in his car. Why was this relevant? Because he parked his car outside of the United States Capitol and just had the guns in the car. And they were technically on, federal property, and the D.C. Circuit said, nope, we're going to uphold the conviction because, the law is valid. But the U.S. Supreme Court in Nyserpa versus Bruin put that on the list of cases that were likely wrongly decided because they applied the wrong test, the wrong standard review. So anyway, that is a very long list, but that is almost the entire full panoply of the anti-gunner agenda, just about, not entirely, but the massive chunk of what the anti-gunners want to do to you and to me across the country in terms of taking away our gun rights. And the Supreme Court just gave you that list in those courts of appeals. They were federal courts of appeals on those topics and basically just threw them in the trash heap of history and said, no good, they were done wrong. So as to what happens next, we'll see these cases similar to this are going to have to be relitigated and handled with the proper standard. Only time will tell what should happen. I think what should happen is all these laws should be struck down as unconstitutional under the new standard set forth by Bruin, but only time will tell and we will see. But I can assure you this, it is pretty clear to me that Supreme Court decision by Clarence Thomas has made the rubble bounce when it comes to these anti-gun precedents by these anti-gun courts across the United States, and thank God for that. Okay, I hope you learned something here at the 4 Boxes Diner. If you haven't subscribed, please do so, and feel free to share this video. Again, we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.